Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery. Today's Doug Austin, and it is the important eDiscovery case law decisions for April of 2023. Faculty experts, of course, Doug Austin, the illustrious Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. This webinar will be recorded and available for replay at your convenience, as are all of our webinars. And you can download a certificate of attendance from the console after the webinar to use for your continuing ed requirements. Kaylee Wallstead, EDRM Chief Strategy Officer, is here with us today. What do we have on deck for resources, Kaylee?
Well, we have plenty, and we are so excited for this monthly, what we call a cult classic case law webinar. So be sure to save your seat for important eDiscovery case law decisions for May 2023. There's a registration link for you to click and already save your seat. And keep up with eDiscovery news and more on the eDiscovery Today blog, curated by Editor-in-Chief Doug Austin, who is enjoying his 3rd anniversary. And how many posts? How many posts, Doug, to date?
Well, including this morning's 1,553.
Woo-woo.
Wow.
Amazing.
Well, if you aren't subscribed, it's a great way to start your day and keep up. And Doug's got a very cool Internet Minute infographic to go check out for 2023. And learn more about Tom O'Connor's Gulf Coast Legal Technology Center. There's a great link with resources and information. And be sure to follow Tom. He is also a font of educational information with a great book out. Tom, what is the title?
eDiscovery for the Rest of Us.
There you go.
There'll be some information on the website about how you can get a copy.
Excellent. Up next on the EDRM webinar channel, May 3rd, Survey Says, top 3 eDiscovery takeaways from a recent survey of over 800 plus CLOs, and learn more about the Honorable Judge Peck and how you can engage with him. And back to you, Mary.
All right, so we do have our wonderful faculty here, and Doug Austin, founder and editor of EDRM Trusted Partner eDiscovery Today, celebrating the 3rd blogiversary. So congratulations again, Doug.
Thanks, Mary.
And Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. And Doug has published a daily blog since 2010 and has earned JD Super Awards 3 times. Yes, and Tom O'Connor, the author of eDiscovery for the Rest of Us, hails from the great city of New Orleans, and for over 3 decades has stewarded the Gulf Coast Legal Technology Center, has a wonderful YouTube channel that has long-form interviews, and a sought-out consultant on some of the largest cases, and he's the author of the great blog site, technogumbo.blog. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright, trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and then later our more advanced opinions on things like boilerplate objections, 502D orders, and technology-assisted review. And EDRM's thankful for all 3 gentlemen for serving on the EDRM Global Advisory Council. And Doug, do you have an internet minute to go over our agenda today?
Nicely played, Mary. Nicely played. Welcome, everybody. And yes, we do have another set of very interesting cases this month, including a dispute over search terms and custodians for a non-party discovery request, sanctions against counsel for failing to respond to discovery requests, proportionality of search terms, possession, custody, and control for agents of golf professionals, sanctions for fraudulent text messages, and sanctions against Google for failing to preserve Google chat messages. And as Mary mentioned, just a reminder, we do welcome questions and we'll try to get to as many as we can. And just so you know, we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers like death and taxes are inevitable. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 29,200 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case involved a corruption and bribery scheme involving 2 nuclear power plants. And here, a joint motion to compel was brought by plaintiffs and defendant Michael Dowling, who asked the court to compel the production of documents which non-party PFP had withheld or redacted. They also claimed that PFP's production thus far had been deficient in 2 regards. It employed a limited search term protocol to identify responsive documents, and it failed to search for documents which were created or received by the attorneys at CalFee representing PFP. After the court ordered PFP to supplement its limited initial production, and PFP did so and explained its search protocol, movements then responded with purported deficiencies in the search protocol, including the failure to include First Energy as a standalone search term and the failure to search for CalFee custodians under inclusive search terms. Movements proposed additional search terms, but PFP refused to perform the search, which they stated would result in over 1,000 unique additional documents to review unless movements paid the costs associated with the search, which was estimated to be in the low to mid 5-figure range. And PFP renewed earlier objections that searching CalFee custodians would be unduly burdensome and would result in only privileged material. Ohio Magistrate Judge Kimberly Jolson stated, "The court finds there are legitimate concerns about deficiencies in PFP's protocol, and the proposed search terms reasonably address those concerns." She cited a couple of examples, including that no variant of First Energy was included as a search term, and stated the omission of several at-issue organizations from the original set of search terms is patently deficient. As for shifting the costs, Judge Jolson stated the court does not find that movements should bear any of the cost of production, noting both PFP's own interest in the outcome of the case, because PFP was funded and controlled by First Energy, the first named defendant in the case, and the public importance of the litigation weigh against mitigation of PFP's compliance expenses. Additionally, recognizing concerns from both the movements and PFP regarding CalFee custodians, Judge Jolson also ordered PFP and movements to negotiate search terms for relevant CalFee custodians. And she granted PFP's request that the court enter an order under Rule 502D, which would allow it to reduce disputed CalFee invoices and certain emails to movements with fewer redactions without waiving privilege. So, Tom, PFP's estimate for additional review of 1,000 plus documents was in the low to mid 5-figure range. Does that seem reasonable, or do you think they may have been trying to inflate the number to make it look more burdensome?
Doug, are you implying that attorneys would try to exaggerate costs during part of their argumentation? That's I'm shocked, I tell you.
Indeed.
Well, you know, the what we don't know is what they were doing for a review. I mean, if the review was going to be done by a senior partner in the firm and she alone was doing them whenever she got time to, the number may be low. You know, if they were using tar, then the number seems exaggerated. So, you know, you'd really want to know what they were talking about for how they intended to review, and I wouldn't just take the number on on face value. I mean, I'm sure, you know, if that number was given to someone like Judge Peck with experience in this area, he would look askance at it. I don't want to presume to speak for him, but you know, the bigger question to me in this one real quickly was, and we're going to have another case on this further on down, but why wasn't the protocol agreed upon? Well, you know, why weren't these issues laid to rest in the report to the court that's supposed to come out of the meet and confer? But as I said, I think we're going to address that again in another case, and I'll save my comments for then.
Sure. Well, yeah, I mean, I guess since PFP was a non-party, maybe they weren't part of that, but I don't know. I guess.
Yeah, but it still should have been addressed, don't you think?
Sure. Well, yeah, I mean, it certainly seems that it was kind of unilateral in terms of how they conducted the searches. So,
yeah.
Judge Peck, as Tom has mentioned to you, I'll ask you a question, and you know, certainly Judge Jolson referenced PFP's relationship to First Energy as one reason why she decided not to shift costs for review. So, as a judge, did you normally treat all non-parties the same in considering burden and cost, or did the non-parties' relationship to the parties in the case impact your cost-shifting decisions as well?
It did. You know, there is a big difference between a related non-party and just, you know, the man on the street, so to speak. Mm-hmm. I mean, you know, if there's an auto accident at an intersection and somebody figures out that a store there has a outside camera and that picked up the accident and et cetera, I mean, that's a legitimate, uninterested non-party. When it's an employee of one of the parties or a supplier to one of the parties or anything else, they may well have an interest and perhaps caused the litigation to have to be presented to the court because it was in their interest or their related parties' interest to drag things out or slow them down or any of that. And I'll note that in the Sedona commentary on Rule 45 and non-party discovery, we took that position that you differentiate between a related non-party and a true non-party. Mm-hmm. One thing before I turn the microphone over, I just want to point out and stress that Judge Jolson entered a Federal Rule of Evidence 502D non-waiver order, and frankly, the parties and non-parties should agree to that in any and every case and present it to the court without opposition.
Yes, I fully expected you would have something to say about that. So certainly duly noted. So Mary, one thing that was interesting about this case is that the plaintiffs and one of the defendants issued a joint motion to compel. How common is that, and when might it make sense for otherwise opposing parties to issue joint motions like this?
You know, I don't know that it's all that common, but it seems like it would get to be more common. As I started thinking about this question, I was remembering a money market fund that I had worked with that got mostly non-party requests for financial documents. So both sides of the V would need the records, and they'd have to go through a whole big, you know, redaction exercise because it was financial records. So with that, or then you think about GitHub in IP litigation, they'd be in the same boat. Or in wholesale retailers, perhaps you know, UPS or FedEx being the shipper and the returner. So I think we'll see more of this kind of thing with the unbundling of services and you know, using the third parties to be a key part of business processes.
Yeah, I agree. I think that it will be interesting to see how much more we do see of it. So yeah, absolutely. Great examples. We'll move on to our next case. Oh, and by the way, just a reminder, yes, we will be sending the slides out later on today. So so fear not, you will get those. So our next case is an employment discrimination lawsuit where Texas Magistrate Judge Andrew Edison began his order by stating, "There are a few things that I truly despise. The short list includes meatloaf, the Ohio State Buckeyes, and hangovers." Hey, I get the last two, but meatloaf? Come on, he was a great singer. He also said, "It is no exaggeration to say that I hate motions for sanctions. All too often, lawyers file motions for sanctions for no legitimate reason. They simply want to obtain some perceived tactical advantage in a case. That is not the situation here." Judge Edison then went on to identify several plaintiff violations, including failing to comply with orders to provide responsive documents, execute the employment authorization and the medical records authorization, supplement and verify interrogatories, and more. But Judge Edison pointed at plaintiff's counsel, stating, "Bosher's counsel acknowledges that he has failed to comply with my discovery-related orders. He tries to deflect blame to a busy trial schedule, an unforeseen client emergency in another matter, and technical issues which resulted in him losing a draft of supplemental discovery responses. None of these excuses are satisfactory. The fact remains that Bosher's counsel repeatedly ignored or flouted court orders." In sanctioning plaintiff's counsel, Judge Edison stated, "In my view, sanctions should only be imposed as a last resort when the conduct of counsel is so egregious and so unacceptable. Unfortunately, this is one such case. For only the third time in my 5 years on the bench, I will award sanctions for a flagrant abuse of the discovery process." He agreed with the defendant's declaration of fees and ordered plaintiff's counsel to pay over $5,000 as a sanction to the defendant. So, Judge Peck, this is the second case in 2 months we've covered where counsel was sanctioned instead of the party. As a judge, in what circumstances would you choose to sanction counsel instead of the party itself?
Well, this is one where it was very easy. Plaintiff's counsel admitted it was his fault, not the client's. Not enough lawyers throw themselves under the bus.
Mm-hmm.
So that's certainly a factor. Who is at fault? Usually you can't tell. Is it the client or is it the lawyer? In which case one can either sanction both of them or sanction the client. And if they want to try to get that back from counsel, that's between them. Another factor is who can actually pay the sanction. If you are entering a sanction to reimburse the other side, and let's say it's a single plaintiff employment discrimination case, the plaintiff is now unemployed, etc., is entering a sanction. I mean, $5,000 here isn't very much, although to some people it could be the difference of whether they eat that month or not. So is it, of any benefit to enter a sanction that the person won't be able to pay or will keep them in debt for the rest of their life? And a third factor is sometimes you want to send a message to the bar writ large, and nothing gets that across to lawyers more than looking at their own self-interest, and there but for the grace of God goes I. So perhaps Judge Edison was trying to shed light on that.
Sure.
Okay, Doug, that was meant as a pun. Edison light.
Oh, shed light on that. I missed it. How could I? Yeah,
Ouch.
I guess my bulb isn't screwed in all the way today. So what can I say? Very nice. Very nice. So now that I'm feeling a bit chagrined, Mary, what recommendations do you have for our audience to avoid being overwhelmed with their litigation caseload?
All right, Sheila Greeley, buckle your seatbelt. Get a good paralegal. So I say that half in jest. Certainly, attorneys need help, and certainly attorneys on the end of pro bono or low bono work, trying to provide services to clients that don't have a lot of resources. Tom, your book would certainly help, the eDiscovery for the rest of us, getting up on how to use technology to to advance the practice so that you're not totally overwhelmed. So I definitely feel for them, because I think it's feast or famine out there in the legal world.
Yeah. As it is for many other worlds as well. So
of course, if I can just add,
absolutely.
sometimes all you need to do is ask opposing counsel or the court for a short extension. If you're overwhelmed with another case for a short period of time, that's the sort of common courtesy that opposing counsel should give. Ignoring deadlines that a court has imposed is never a good idea.
Yeah.
Indeed, yes. Courts don't like to be ghosted. Go figure. So Tom, obviously, while the plaintiff's counsel did take responsibility, should there have been some sanction for the plaintiff himself for failing to comply with his own discovery obligations?
Well, I think you would think so, given just looking at the case generally, but the judge seemed to focus in so extensively on the actions of counsel that I think that that was the judge's real intent here, was to reel the lawyers in. I mean, that's an amazing slide that you have posted up there for the recurring statements, and I think somewhere I read in the decision he wrote, I could write pages and pages about how Boshear's attorney has made a mockery of the discovery process, end quote. So I think, as on the slide, he repeatedly ignored or flouted court orders, a flagrant abuse of it just goes on and on. So I think maybe whatever the client may have done or not done was lost in the fire.
Sure, makes sense. We thank Judge Edison for not writing pages and pages about that, because we have a bunch of cases to get through each month, and this one wasn't too bad. So, all right, we'll move on to the next case. And this case is one where the court seemed to be a bit in the dark on what was happening. It involved claims of misappropriation of trade secrets and unfair competition as part of 13 claims against the defendants. And the parties submitted a joint briefing to the court that Arizona District Judge James Teilborg said does not lay out an exact chronology of when the plaintiffs first made objections and the scope of those objections. As part of that uncertainty, the parties agreed to ESI protocols, which the court did not get a chance to adopt or reject. After some negotiation on search terms, the parties agreed to run their respective search terms, and defendants produced their responsive documents in March. However, the plaintiffs objected again on January 9th, then supposedly agreed again to run defendant search terms. Then they made another round of objections on March 3rd. They agreed that over 122,000 responsive documents must be produced, but argued that the remaining documents were so voluminous they were objectionable. Regarding the defendant's claims that the plaintiff's objections were untimely, Judge Teilborg stated, if the court were asked to rule on these protocols back in July 2022, the court would have found that the parties' protocols are unmanageable because they do not set a specific time frame for objections. The parties' poorly crafted protocols defeat defendant's argument that the objections are untimely. Judge Teilborg also rejected defendant's contention that the plaintiff's objections were boilerplate, citing an example where the plaintiffs objected with specificity. But Judge Teilborg also found the search results of over 400,000 documents proportional to the needs of the case, stating, regarding proportionality, the court agrees that 409,988 responsive documents is voluminous. However, plaintiffs chose to bring a wide-ranging lawsuit based on 13 claims for relief, 8 of which relate to the remaining defendants. Additionally, plaintiffs are seeking more than $16 million in damages, plus as yet unquantified continuing damages, punitive damages, attorney's fees, and costs. The court finds that the ESI sought is proportional to the case as a whole. So Judge Teilborg overruled plaintiffs' objections and ordered them to respond to defendants' requested discovery, while noting they could still review for relevance and withhold irrelevant documents. So, Mary, what could the plaintiffs have done, if anything, to more effectively support their argument that nearly 410,000 documents was unduly burdensome?
Well, I think when you look at burden and proportionality, you're looking for some outer limits on what the damages would be, and the plaintiffs themselves, as the court said, right, they chose to bring a wide-ranging lawsuit based on 13 claims for relief. So certainly they could cut those claims for relief down. And then they're seeking 16 million in damages, but they've got unquantified continuing damages, punitive damages, uh, and then the normal attorney's fees and costs. So the upper limit is pretty big, and they didn't do anything to bring that down. So I think that plus a nice budget might have helped them.
Sure. Certainly, it seems like maybe they could provide some particulars about the terms and about the results and so forth that might have maybe helped as well. But certainly, yeah, big case requires big discovery, and you signed up for it. I guess you're going to have to live with what you signed up for, right? So, yeah, absolutely. So, Tom, Judge Talborg cited the parties' poorly crafted protocols in ruling against the defendant's argument that the objections were untimely. So, what recommendations do you have for our audience to minimize the potential for issues with their ESI protocols?
Well, and I see this a lot because I work with clients on protocols. Protocols have become weaponized. Mm-hmm. They're treated like a pleading. They're not treated like an agreement to try to get something done. And more often than not, a case I'm involved with right now, one side was so intransigent that, they just refused it. Here's what we offer, and that's it. This is how we're going to produce things because that's the way we've always done it. So we're going to ride our horse to the courthouse and then go send a telegraph after we're done dropping off the paper because that's the way we've always done it. And the other side my client in this case just kind of says, you know what, we're just going to let it go. They're going to do exactly what happened. Let's wait till they produce something, and then we'll bring our objections then. So protocols aren't really, in my sense, from what I'm seeing at least, protocols. They're really just sort of this nebulous half agreement to start producing documents and dump it in the court's lap down the road. The other thing, and I mentioned this in the first case, even though that was a non-party, I think if this happened, if in fact in the written report to the court that under 26F is supposed to occur within 14 days of the meet and confer about your discovery plan, which is supposed to discuss any issues about disclosure, discovery, and preservation, include the protocol. And if you can't get it out there, then put that in. So the court has some notice then within 14 days of the meet and confer, like, this is kind of vague. What's going on here? And they have something to look at and maybe give some guidance to, or before you even do that, bring it to the court. I have another case now, a different client than the one I just mentioned, where that's exactly, they took my advice and that's what they're going to do. They're going to bring it to the court. So, but don't weaponize it, and don't say, yeah, okay, we'll figure it out after they start producing, because that just, kicks the can down the road right into the judge's lap.
Yeah, absolutely. Protocols have been challenging, and so not everybody's a fan of them because for the very reasons you cite there, Tom. So absolutely. Speaking of kind of getting the court involved, Judge Peck, it seemed as though the court was in the dark about the timeline of events and the parameters of the ESI protocol until much later. So what can parties do to minimize the need for court involvement on discovery issues, yet ensure the court is sufficiently informed to rule when there is a dispute that can't be resolved?
I mean, in defense, not that I think he needs it, of Judge Talborg, the court is supposed to be uninvolved unless and until there is a dispute, once the court has set the parameters of the discovery plan. So not surprising that the judge wasn't. What's important is at the time of the motion or appearance in front of the court on the discovery dispute, to lay out all the facts, all the timeline in a very clear way, so the court knows what was agreed upon, what wasn't agreed upon, what was kicked down the road, as Tom mentioned, etc. Now, if the protocol had been a stipulation and court order, which it wasn't here, it was a sort of stipulation, and it certainly was never presented to the court. Where it's a court order, it then becomes binding. And one of the other problems we see with protocols is, as it used to be said about the plan for a battle doesn't survive the first meeting with the adversary. Similarly, protocols often are drafted before the parties really know what's in their data or how big the data is, and therefore, wind up binding a party to something that doesn't make sense. I mean, we've seen that a lot with protocols that talk about keywords and manual review. Then the volume is so high, a party wants to use tar, and the court says, normally, sure, but your protocol here says you're not, so you can't. I also want to make one other comment. I'd love to know where the $16 million damage number came from. Was it a realistic number, or was it just the amount, in the ad damnum clause in the complaint, which we used to call phone number damages, because there's always 3 extra zeros attached or whatever to bring it up to the full phone number, including area code. So, what is a realistic number? The party may have put 16 million in the complaint, but the realistic number might have been 1 million or so. That's an important factor when one is looking at that in terms of proportionality.
Sure. Yeah. Of course, in this case, Judge Teilborg kind of held the plaintiffs responsible for their claimed damages. So that kind of, I guess, cost them, at least in terms of the having to produce or to review and produce the documents. So certainly interesting proportionality exercise for sure. So, all right, we'll move on to the next case, which I had actually accidentally already moved to in the slides. Now I'll move back to it. On to case number 4. See what I did there? This case involved, thank you. Involved professional golfers that were members of the PGA Tour who signed contracts to play in a rival professional golf league, the LIV Tour, and their suit against the PGA after they were suspended for violating PGA rules. If you're a golf fan, you're certainly familiar with this case. This particular dispute involved the collection and production of custodial ESI from agents representing several professional golfers who accepted service of but did not fully agree with the PGA Tour subpoenas seeking the production of documents. And the PGA Tour subpoenas define the responding party as including the player's attorneys, agents, members, or employees, or any other person acting on their behalf. California Magistrate Judge Susan Van Keulen stated, "The federal rules require production of documents that are within the possession, custody, or control of the responding person or entity. That standard applies no matter whether the responding party is a person is a party to the litigation or a third party subject to Rule 45. She also stated control is generally defined as the legal right to obtain documents upon demand. Continuing, Judge Van Keulen stated, "It is not credible that the players cannot obtain responsive documents from their own agents, which with the use of limiter terms relate only to the agent's representation of the players. The players focus on the means of identifying responsive documents via agreed upon ESI search terms is too narrow. The reliance on Rojas versus Bosch Solar Energy Corp. And its analysis of control in the context of complex corporate structures is similarly misplaced. In the Rojas case, the court had ruled that the plaintiff had not shown that the defendant had a legal right to obtain any documents in the possession of related companies or the defendant's outside legal counsel. So Judge Van Keulen stated the court concludes that custodial ESI, email, and device level data in the actual possession of the player's agents is within their control within the meaning of Rules 34 and 45. So she ordered the plaintiffs to run the search terms, produce non-privileged materials, and provide a privilege log. So, Tom, do you think the golfers' objections to including the data possessed by their agents was a slow play tactic, or do you think they had a legitimate position that data was within the agents, or that data within the agent's possession was not within their control?
Well, you're being very kind to pleading parties here today. First, it was inflating a number in the first case, and now it's a slow play tactic instead of being obstructionist.
Yes.
The judge said at one point in her holding that, quote, under the established Ninth Circuit law, materials in the possession of an agent are within the control of the responding person and must be produced, end quote. And then she had the further quotes that you talked about, the meanings of Rules 34. How did they not know that? Right? There's a difference between slow play tactic and not knowing the law in the jurisdiction in which you're pleading. The comments to a commentary to the case that Kelly Twigger, your source or your wonderful source for some of the cases here is she talked about that very thing. She said, you need to understand the law of the jurisdiction you're working in, end quote. So I'm baffled.
Yeah. Kelly had a great discussion of the case on her Case of the Week podcast that she did every week, and was one of the reasons I picked this case because it was interesting to me. So one of the things, Judge Peck, I'm interested in is the plaintiffs mentioned the Rojas case, and in that case, the court found the defendants did not have the legal right to obtain documents from parties with some relationship to them, including their outside counsel. So when should parties be considered to have a legal right to obtain documents from related parties versus when they don't?
I mean, among other things, one has to look at the contractual relationship between the parties.
Mm-hmm.
You mentioned, for example, a law firm. I don't think that if a client of mine got sued, all of my documents about the case really are theirs. Certainly, the law has always been clear that you can't, as the company, say, I don't have possession of the documents anymore because I gave them to my lawyer. But not everything that the lawyer has is within the possession, custody, or control of the company that they are representing. And I wonder here, and I don't know, and golf is not my sport. I never got beyond miniature golf and anything, but were they concerned that the agents probably were representing, multiple golfers? And was this attempt at subpoenaing them for their agents' data an attempt to not only get their information that the agent had, but other information about other golfers that the agent may have had? Of course, one could go subpoena the agent directly if they were in the right jurisdiction. So, and I guess the last thing I would say is we are seeing this a lot in the cases with regard to BYOD devices. And depending on what the terms of the company BYOD agreement is with an employee, may well determine whether the company has the legal right to data on the employee's cell phone.
Sure. Yeah, absolutely. And that's we had a case a couple of months ago that dealt with that issue. So certainly interesting to kind of note how that kind of evolves there. So Mary, being a party in a case like this, what recommendations do you have for our audience on how to determine how to address the ESI from third parties that they work with?
Well, I think if they haven't done it in a litigation readiness or data mapping exercise, it's done right at the beginning of the identification phase and interviewing witnesses to find out what third party ESI would be at issue, and to determine how to get it out, there's some variables in there. Who's got the username, password, encryption keys if there's encryption. How long would it take to extract from a technical sense? How long would it take to extract from an organizational sense? Who needs to approve these kind of data requests and productions? So I think it's either upfront in your litigation or in some form of proactive exercise to actually document how this is done from the beginning. And if you're lucky enough in legal to have a seat at the table for application justification or change control, that's also a place for it.
Sure, those absolutely great points. Got a comment and question from the audience here. It doesn't sound as if there was an actual showing that the players had a legal right to the documents in possession of their agents. The court said it wasn't credible that they did not have a legal right. Was the court's ruling based on an assumption that a player would always have a legal right to documents in the possession of his or her agent? Thoughts?
Yeah, I mean, I think that was a great comment by Gareth. The court almost was using a practical ability test. Well, of course, the golfer is going to be able to get stuff from the agent while applying the test in the Ninth Circuit in California of the legal right. So there was either information that just didn't make it into the opinion, or the court was exercising its discretion, shall we say, to come to the conclusion that it did.
Yeah, and it was a very short opinion. So this is one where maybe a little more detail might have been useful. So even though we don't mind a short opinion every now and then, it is interesting to sometimes know what could be what's missing. So we'll move on to our next case, which is an interesting case suggested by Judge Peck. That went through 3 different judges. It involved various employment-related claims where the defendant alleged that the plaintiff produced fraudulent text messages in support of his action and spoliated other text messages. The matter was referred to by presiding Judge Richard Bennett to Magistrate Judge Mark Colson for resolution of all discovery disputes, and Judge Colson issued a report and recommendation for this court's consideration in ruling on the defendant's motion. Judge Coulson found the authenticity of plaintiff's text messages implausible, but concluded that there is insufficient forensic evidence to allow the court to conclude there was fabrication. Then the plaintiff was deposed, and during the plaintiff's deposition, defense counsel identified several inconsistencies and incompletions in the text messages produced by the plaintiff and advised him on multiple occasions that he was under oath and subject to the rules of perjury. Yet plaintiff continued to deny any changes to the text messages, also suggesting that Verizon erased the missing text messages and also that covert government agents were responsible. Yeah, that's the ticket. While still on site at plaintiff's deposition, the defendant requested a forensic examination of the plaintiff's phone, which was granted. And guess what happened after that? 3 days later, plaintiff's counsel moved to withdraw their appearance from the case. Subsequently, the defendant filed a status report with the court attaching the report of its expert forensic examiner, which stated the opinion that plaintiff had targeted for deletion the missing text messages and that certain text messages plaintiff relied on to support his claims were not genuine and were altered. So Judge Bennett found that plaintiff produced and relied upon fraudulent text messages, but chose not to dismiss plaintiff's case, instead choosing to constrain plaintiff's presentation of evidence at trial. The action was then transferred to a 3rd judge, Maryland District Judge Julie Rubin. After evaluating the record, Judge Rubin stated, "The intentional and egregious nature of plaintiff's conduct, which demonstrates a disregard of the federal rules of civil procedure and a willingness to commit fraud on the court to prevail and receive an award of monetary damages, not to mention the resultant material injurious effect upon defendant, shocked the conscience of the court, so much so that the court questioned whether it could, in good conscience, submit any of plaintiff's evidence or testimony to a jury." So Judge Rubin dismissed the case with prejudice and ordered the plaintiff to pay $10,000 to the defendant as partial reimbursement of costs for the forensic examination. So Judge Peck, this case involved rulings from 3 different judges and a forensic examination to confirm that the text messages were fraudulent before the case was dismissed. Could some of those steps have been avoided, or did it happen here because courts want to do everything they can to avoid dismissing cases with prejudice?
Well, certainly the latter applies. You don't want to dismiss a case that might have merit because of certain defects in discovery. Once it gets to the point of fraudulent evidence, you really are, there, or the court can be nice, but you can't let it go. I will say that it is typical in the federal system for 2 judges to be involved in many cases. The district judge to whom the case is assigned, and then if that district judge refers it to a magistrate judge for supervising discovery and other purposes. The fact that there's a 3rd judge here, an additional district judge, is unusual, but often happens when a judge retires or a new judge is appointed to the court, and so caseload is reassigned to even out the caseload. So the existing judges will give a certain percentage of their cases to the new judge. The forensic examiner part seems to me, it's exactly how you prove this sort of creation of false evidence. One can assume it from certain things. Plaintiff had a copy of it. The defendant, who supposedly was in communication, didn't, et cetera, et cetera. But, better to have a good full record than to go off without that. I would also add that it didn't help plaintiff's credibility when plaintiff claimed that, the messages were changed because Homeland Security came in and modified it. And, that goes along with the Martians changed my messages.
Right. Yes, that was. The plaintiff did not do themselves any favors in that regard, for sure. Well, certainly this case kind of brings back memories of the Rossback case from a couple of years ago, in the case of the smoking emoji. If you all remember that one, that was another case where forensic examination determined the fabrication of evidence there. So, and I
do. Okay. Do think that with the ease of creating false evidence now, false videos and other doctored evidence, some of which is so good that you couldn't tell by looking at it, that we are going to see much more forensic examination being needed.
Yeah, I agree with that, and I definitely expect more of these types of disputes, for sure. So Mary, Judge Peck alluded to plaintiffs not doing themselves any favors in the deposition, and plaintiffs' counsel requested withdraw from the case after that deposition. So what can counsel do to determine whether they should even take on a client in the first place before it gets that far?
Well, I think we got a hint in the case, because while still on site at the plaintiff's deposition, the defendant requested a forensic examination of the plaintiff's phone, which was granted. And 3 days later, the plaintiff's counsel moved to withdraw their appearance. So perhaps, as Judge Peck intimated, assessing the evidence at the get-go of the case, I think also is spelling out in an engagement letter what would be grounds for withdrawal in terms of, being forthcoming on evidence and not altering evidence and that type of thing. And the other thing is and this is a challenge, I think, probably for a lot of attorneys, to to determine does the person need legal help, or does the person actually need mental health help?
Nice.
Very, very good point, and great point about the letter spelling out those conditions. Definitely, I think that's something more counsel could certainly do. So, Tom, what can requesting parties do, if anything, when making requests to deter producing parties from producing fabricated evidence in the first place?
Well, I don't know if we can do anything at the onset. I mean, there's always the assumption that we're all playing by the same rules and everybody's being fair and honest, even if they are inflating figures or slow playing evidence. Nobody's assuming that the other side is trying to falsify evidence at the onset, as this one showed, as this case showed. The parties, the defense counsel, were able to pick up on some inconsistencies and incompletions in the messages themselves that led them to believe there was something going on. And of course, then when the when the plaintiff starts talking about this, he led with the SODI defense. One in criminal law we hear all the time, right? Some other dude did it,
right? But
then the X-Files defense, I think, was the clincher. As Judge Peck said, the Martians did it. That's oh boy, and then leading to the attorney to withdraw. So, I think this one is beyond the pale. We don't usually see this, and you're assuming at the onset, at least, that everybody is playing fair. And of course, the attorney is signing affidavits attesting to the accuracy and truth to the best of his knowledge of what's being filed. So it wasn't until they got the plaintiff under oath himself that he started to lose his grip, so to speak. So.
It's I think the plaintiff could tell how well he did on the deposition when his counsel quit 3 days after.
Right.
Usually not a good performance. So
not a good sign.
Right. So, all right, we'll move to our last case, which involves a unique situation, spoliation of data from an app created by the party of that data. In this MDL action involving multiple antitrust cases challenging Google's Play Store practices as anti-competitive, the plaintiffs asked Google about a curious lack of chat messages in its document productions. 6 months later, Google said that Google chats are typically deleted after 24 hours and that Google had not suspended this auto-deletion even after this litigation began. Google chose instead to let employees make their own personal choices about preserving chats. California District Judge James Donato's ruling, including a findings of fact and included a findings of fact and conclusions of law, where he noted that Google is a frequent and sophisticated litigation party. They trained their employees to communicate with care. They used Google Chat daily, and it was essential to their communications. Google has the technical ability to set chat history to on as the default for all employees who are subject to a legal hold but chooses not to. And many employees disregarded litigation hold instructions. And if you go to the case, you'll see an example of that. There were a couple that the judge included in the ruling, but one where it was clear that an employee was just simply disregarding litigation hold instructions. Regarding Google's conduct, Judge Donato stated, the overall propriety of chat is not an issue here. What matters is how Google responded after the lawsuits were filed and whether it honored the event's preservation duties it was abundantly familiar with from countless prior cases. The record establishes that Google fell strikingly short on that score. Noting that Google's handling of chat was in sharp contrast to Google's handling of email, where Google automatically preserves all emails from relevant custodians without requiring any individual action, Judge Donato stated, the principle of proportionality demands that the remedy fit the wrong, and the court would like to see the state of play of the evidence at the end of fact discovery. At that time, plaintiffs will be better positioned to tell the court what might have been lost in the chat communications. However, Google was sanctioned for Google Chat spoliation in that Judge Donato stated, it is entirely appropriate for Google to cover plaintiffs' reasonable attorney's fees and costs in bringing the Rule 37 motion, including the joint statement that preceded the motion and the evidentiary hearing and related events. So, Mary, do you think this was a case of commission by Google to avoid producing chats, or omission and following up like they should? If omission, what should parties do to help ensure that chat data isn't spoliated?
Well, I think it's a special case because they're the creator of the app, so they would have the maximum, most amount of knowledge about the app and how the app works, compared to anybody else in the whole entire universe.
Sure.
So choosing to allow individual custodians to turn on tracking for individual conversations or for themselves as under a legal hold rather than having that supervised, I mean, that's a very deliberate decision. So it might look like omission, but I'm gonna err on the side of commission.
Interesting. Yeah, it's certainly odd that it's a app that they have total control over, and they chose not to exercise that. Certainly, Tom, we're seeing more and more cases involving failing to preserve chat data, even from a company as big and litigation aware as Google. So what recommendations do you have for our audience to ensure their preservation instructions stay current with changing data sources?
So I'm seeing this all the time with clients who consult with me, and I've got one right now where this very issue came up. Major production, we look through it, no chat messages, and we think that is, in that case, omission. As Mary just said, however, Google's certainly different. The court themselves said they're no stranger to these sorts of things, and I thought the telling statement that you had in the middle of the slide there is, the record demonstrates that Google employees who received the litigation hold in this case were unable or unwilling to follow the chat preservation instructions and sometimes disregarded the instructions altogether, end quote. I'm sorry, so why are they still employees?
Right.
You got, if in fact it would seem from reading that people were told clearly what to do, is the omission that occurred not following up, and we see that a lot, that the litigation hold is a one and done. You send instructions out and that's it, game over. But that's clearly an act of omission. You've sent out instructions and people are saying we're not going to do it, or they're disregarding. I mean, somebody needs to be following up on that and taking appropriate action. And
but if I can jump in.
Sure.
Employees' jobs are to run the business, to sell product or do, whatever. And you can't just say, if they don't follow the lit hold, we're going to fire them or discipline them.
Sure you can.
Because you're going to find out that it's,
Google does it all the time.
It's but when it's at the CEO or C-suite level, or it's the sales person for a different company that always makes the $1 million sales club or whatever. Legal does not run the business.
Yeah, well, that's unfortunate. Yeah, I suspect you're right. I still think there could have been better supervision. Firing, maybe not. Certainly at the top of the or anywhere in the C-suite, but there were a whole lot of employees involved here, and something could have been done.
Sure. Well, I mean, they could have set it to turn history on to begin with, and then they could have still followed up. So they really missed the boat on two occasions. One is to not set it on, and then the second is not following up to ensure that they are, preserving that history. So it's the age-old turn off auto delete when subject to litigation. So
maybe because the court noted how familiar they were with doing it, maybe there was some fatigue. Maybe there was some lit hold fatigue going on.
Sure.
Right. They've had so many, they're spending all their time preserving documents. And as the judge said, that's it. Enough.
Mm-hmm. Sure. That's a potential cause for sure. So Judge Peck, with fact discovery not concluded, Judge Donato noted that additional sanctions were possible. So how would you handle determining what those sanctions should be, and what information would you expect from the parties to make an informed decision?
Well, one of the things you'd want to know is how important were the messages, the chat messages that disappeared. That may or may not be something that would be learned through additional discovery, through depositions, for example. So, under a 37E1 analysis, was this something that resulted in prejudice to the other side? So that would be a factor. I mean, another sanction could be an adverse inference. So it may get to the point where there is enough evidence, either indirect evidence of an intent to deprive, if, for example, following up on what Tom was saying, Google knew that employees were not following the direction to save individual chats. There could be a heavy adverse inference under 37E2, a lighter adverse inference under 37E1. And then the final point I'll make, I don't think that was the situation here, but judges sometimes throw out that threat of, I'm going to be watching you, and some more sanctions can be imposed merely to get parties to stop playing around and start doing what they're supposed to. I know we saw that might have been one of Judge Johnston's DRI decisions. I don't exactly remember, but you can clearly see when a judge is saying, you just wait, you violate my orders again and bad things will happen.
Yeah, we have seen a few cases where we've seen those warnings from judges. So certainly will be interesting to see how this case progresses and what other additional sanctions there will be. So we know we're at the top of the hour. Before we get to the contacts page, shameless celebration warning, as Mary indicated at the top. This is the 3rd anniversary of the launching of eDiscovery today. As you can see on the right, we've been a little busy in these first 3 years, covering not just eDiscovery, but also InfoGov, data privacy, cybersecurity, and AI. And we published over 350 posts about case law, many of them involving cases we've discussed right here on this webinar. To celebrate today, eDiscovery Today and Legal Tech Media Group published our first ever Internet Minute infographic this morning, which illustrates what happens with various data sources every minute on the internet. So feel free to go check that out on eDiscoveryToday.com, all one word, no dashes. And thanks to all of you for supporting eDiscovery Today these last 3 years.
Great job, Doug.
Thanks, Tom. And with that, I'll go to the contacts page, and we do have a date for our next case law webinar, which is Tuesday, May 30th. So save that date. And until then, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary.
Thanks, Doug. And Kaylee? No.
I was muted.
Oh, you're immutable, Kaylee.
Yep. So quick going over the attachments, which is the paperclip on the right side of your console. You can already register and save your seat for important eDiscovery case law decisions for May 2023 on May 30th, as Doug just shared. Keep up with eDiscovery today. Go check out the cool Internet Minute that Doug has put together. The link to his blog is right there, and be sure to subscribe. Check out Tom O'Connor's Gulf Coast Legal Technology Center. The link is there with great resources. And your book, Tom, eDiscovery for the rest of us. It shows you right there how to get it, right?
Yeah, it's on the website. That's right. There's a link there's a store link at the top right of the banner on the website, and it'll take you right to where you can purchase the book. Very moderately priced, I might add.
Perfect. And you can click the link to learn more about Judge Peck and how you can engage with him. You can also see what's up next on the EDRM webinar channel, May 3rd, Survey says top 3 eDiscovery takeaways from a recent survey of over 800 CLOs. Back to you, Mary.
Well, we are very grateful for Doug Austin and our trusted partner eDiscovery today for anchoring this wonderful webinar, and for Tom O'Connor and the Honorable Judge Peck for their insightful presentation. And our thanks to the EDRM community for your kind attention. We'll see you next week on the EDRM Global Webinar channel. Thank you.
Thanks, everyone.
Bye
Thanks
bye
for-
all.
Thank you.